Any mention?
May I please, Your Lordship? Lordship, I beg to mention item number 13. I pray for 2 weeks' time, Your Lordship.
Item 13.
Item 13, Your Lordship. 1-3.
You are private respondent.
Yes, for the
That is
Assam,
Union of India, isn't it, respondent?
the Union, Your Lordship. I for respondent 3 to 5, Your Lordship.
What is this matter about Mr. Damnath?
Matter about the national public, some level public school. This is the for salary and allowance. So, petitioner is asking for the Central Pay Commission, 7th Central Pay Commission.
And who is the private respondent?
And for the Assam,
This is the Assam Rifle.
You are the school. ARPS, Assam Rifle Public School. Okay. Yes. Any objection?
No objection, Lordship.
Yes. For how long you want?
2 weeks, Your Lordship.
So, on request made on behalf of the respondent person, so not objected to by the latter comes of the petitioner, at least after 2 weeks. 2 weeks? Yes.
Highly obliged, Your Lordship.
Your Lordship, I beg to mention item number 3, Your Lordship.
Yes.
Your Lordship, the connected matter is pending before the division bench, Your Lordship, which has a
Sometimes
bearing
you
on
say
this
connected
matter.
Sometimes you say it's.
Yes, yes,
It is connected.
yes. Not connected, my lord. It will have a bearing on this matter.
Okay. The learned counsel, the learned counsel appearing for the party submit that a connected matter pending before the division bench is yet to be disposed of. Stop. Paragraph in view of the submission. This is matter after 4 weeks.
4 weeks.
When the division bench matter is likely to be
There is no certainty.
after 4 weeks. Yes.
Deeply obliged.
May it please your lordship.
Yes.
Lordship, I beg to mention item number 11 and 12 of today's daily list. The conducting counsel have some personal difficulty. If the matter may be taken up after 3 weeks.
Yes. Union. No objection. After 3 weeks. Other request made on behalf of the petitioner, not objected to by the learned counsel of the respondents. Yes.
Obliged, Lordship.
Obliged, lordship.
May it please, Your Lordship. Your Lordship, I beg to make a mention of item number 14, 15 and 16, Your Lordship.
All these are connected matters.
Yes,
My
Lordship, this is a connected
Yes.
matter, Your Lordship.
What is your prayer here?
Your Lordship, kindly this matter may be listed after 3 weeks, Your Lordship.
What is this? At the request made on behalf of the petitioner, list after 3 weeks. Yes.
Highly obliged, Your Lordship.
Please, Your Lordship, I beg to mention item number 7. Your Lordship, this item number 7 at the same time also there is a direction by this honorable court to the respondent to file the additional affidavit.
Lordship, I find the additional affidavit in the course of the day, Lordship.
No, that is okay. But then what for you are making mention?
Will not take it today for adjournment.
Okay. So when do you want it?
1 week, Your Lordship.
Lordship, I'll be finding in the course of the day, Lordship. I don't know objections.
Yes. Mr. A. Karwanlang, learned additional synergy appearing for the respondent number or all the respondents?
All respondents, Lordship.
All the respondents, appearing for the respondents submits that. What affidavit?
Additional affidavit, Lordship.
Submits that the additional affidavit will be filed during the course of the day. So in view of the submission made. This is matter after 1 week.
1 week.
Yes.
Similar prayer with item number 21. Your Lordship, in this
Item number 21.
21, Your Lordship.
Item number 21, who is the respondent?
21 is this case is still pending washing. There's pending one case is pending before the
DB.
So
Then 3 weeks?
3 weeks.
3 weeks. Yes. 21. Yes.
obliged, Your Lordship.
My lord, Lord, I beg to make a mention of item 8, my lord. It's kindly
Yes.
listed after, maybe taken up after 2 weeks.
What is this matter about?
My lord, this is regarding teacher, my lord, termination,
Service matter.
service matter.
Yes. 21. The request made on way of the state respondents. List after 2 weeks.
Obliged, my
Yes.
May it please, Your Lordship.
Yeah.
Lordship, I beg to mention item number 6. Lordship, I paid for 2 weeks' time.
Item 6.
Yes, Your
You are
Lordship.
for the respondent.
Yes, Your
I'm for the petitioner, Lordship. Yeah.
And what is the matter about? Here also it's a service matter.
Yes,
Lordship. Your
Lordship.
Lordship.
And you are?
Yes.
You are not the state. You are?
Respondent, Lordship.
Respondent 3 to 5, Your Lordship.
Who are there?
Bakmara Municipal Board, Lordship. Bakmara Municipal Board.
Municipal.
Yes,
Municipal. Yes. Any objection? No objection.
No, no.
Just one prayer made on behalf of the respondent number so and so, not objected to the learning counsel of the petitioner. List after
2 weeks, Your Lordship.
yes.
Obliged, Lordship.
May it please your Lordship. Lordship, I beg to mention item number 22, Your Lordship. Your Lordship, the matter is pending before DB. Kindly grant 3 weeks of time.
3 weeks. 22.
Highly obliged, Your Lordship.
Yes. Other request. Yes.
May I please, Lordship, I beg to mention item number 17, Lordship.
Yes.
Lordship, in this matter, sole respondent is not appearing, Lordship. One more opportunity may be granted to the respondent, Lordship.
We will not give. Once it is listed for hearing, it will be. If you want adjournment, that's a different thing. But then this will remain open for them. Whenever they want, they will participate.
One more opportunity may be granted, Lordship.
What opportunity? What for? What opportunity?
After 2 weeks, Lordship.
17. One prayer made by the learned counsel of the petitioner. List after 2 weeks. Yes.
Much obliged, Lordship.
May I please, Lordship?
Yes.
My lord, item number 9 and 10.
Yes.
My lord, 2 weeks.
Why? Why do you need 2 weeks?
My
Is
lord,
it
that,
service?
my lord, this is with regards to that ACP and MACP, my lord.
No objection, Lordship.
19. One prayer made by the petitioner, not objected to by the learned counsel of the respondent. List after 2 weeks. Yes.
Obliged, Lordship.
My lord, I beg to mention item number 90. May I pray if the matter can come up after 2 weeks, my lord, relating to the forest departments and the powers.
In that case. This is also the request of the learned counsel, learned state council appealing for the petitioner. This is matter after 2 weeks. Yes.
Highly obliged.
Please, Lordship. Lordship, I beg to make mention item 4, Lordship. Lordship, in this matter, it required to take instruction, Lordship, regarding to proceed with the matter or...
See, you are taking every time this matter comes
Yes,
up, you are
Lordship.
taking time for 1 week, 1 week, 1 week, and every time it's continuing. So we will not adjourn it today. We will have it.
Lordship may give it last
this is
opportunity
not-
1
you should
week,
not take it
Lordship.
as granted. You see, every time the same thing is happening. Every time same thing is happening.
If it's like 1 week, Lordship, of our last opportunity, Lordship, take instruction.
Let it be 2 weeks, my lord. Let
Exactly,
them-
Mr. Sangupta. That is what the thing is. That if you require some more time, you take time, but then do not come back with the
Yes,
same prayer again.
that's
and
what
again.
my lord.
That is what they are doing. This code indicates the same thing again and again to them, but then they are carrying on the same thing. In spite of grant of several opportunities. Come on, the learned counsel for the has not come up with the instruction as required to be taken by him. Stop. Today, again a prayer has been made on behalf of the petitioner to adjourn the matter for taking instruction.
Your Lordship, I'm for respondent 8 and 9. 8 and 9.
Since enough, give a stop. Since enough opportunities have been granted to the petitioner, the matter is urgent to 2 weeks as a last chance. It is made clear that no further adjournment will be granted on the prayer of the petitioner.
Lordship, I have similar prayer for item 5, Lordship. In this matter, the counsel she's indisposed, Lordship.
Now you should be ready with these old matters. If you do it, or you ready for dismissals. What happened is item 18?
Lordship, item 5,
Five,
Lordship.
my lord.
The
Item
counsel
5.
she's indisposed, Lordship. Ms. B. Kharwan Lang, Lordship. So,
Item 5, you are there.
yes, Lordship. On behalf of Ms. B. of Kharwan Lang, Lordship, she's counsel in this matter.
This on prayer made on behalf of the petitioner not object to the learning counsel of the respondents. List after 2 weeks.
Yes, Lordship.
All right, my lord.
May it please your Lordship.
Yes.
Your Lordship, I beg to mention item number 20 of the daily list, your Lordship.
Yes.
Your Lordship, I pray that the matter may come up after 3 weeks, your Lordship.
This is civil division.
Yes, your Lordship.
No objection, Your Lordship.
20. 3 weeks as the request made on behalf of the petition. Yes.
Highly obliged, your Lordship.
Item number 1.
Lordship, I have submitted my affidavit in service.
Yes. What happened? Have you taken steps?
Yes, Lordship, I have taken step on the 8/5/2025, and they have received on the 10th.
No, but then what for you filed the affidavit? Who told you to file the affidavit?
Lordship,
Is there any order by this court asking you to file an affidavit? Then? We are waiting for normal service report. You file affidavit only in the event when there is no report.
okay, Lordship.
Then
Apology from my side, Lordship.
you are to go by the order of the court, not to create your own system. These are tracking details. It is not a certificate of this thing, service. It's not. It cannot be accepted, this affidavit. You have to obtain certificate of service. You will appear for the state.
Yes, my lord.
Yes. Yes. The official indicates. Just a minute. Just a minute. It is submitted by the learned counsel for the petitioner that step for service or notice. The notice upon the respondent number 2 and 3 has been. Don't say steps for. Just say notice for service. Submitted notice was issued to the respondent number 2 and 3. Learned counsel was okay. Learned counsel is stop. Then you say the. However, the office note indicates that service report. The report of service of notice upon the said respondent is yet to be received. The learned counsel for the petitioner submits that an affidavit in support of service of notice upon the respondent number 2 and 3 has been filed. A perusal of the service affidavit shows that it was filed on the basis of the track, what do you call it? Track consignment.
Yes, Lordship.
On the basis of the
Website, my lord. Website portal.
website portals. No,
Website.
but then what this document is called?
So they just want to place it on record, probably, my lord. Probably they just want to place on record that they have. Probably they posted it themselves, my lord.
Yeah, just say on the, that is based on the track consigned, downloaded. From
It's a postal tracking consignment record from the GPO.
Say loudly.
Say loudly.
It's a postal tracking report from the GPO.
Postal tracking report. Based on the postal tracking report, and not on any certificate issued by the concerned postal authority. Stop. The petitioner shall file a fresh affidavit, a fresh service affidavit after obtaining a certificate of delivery of notice from the notice issued by the postal authority. Stop. List after 2 weeks. This is called tracking details.
Tracking details. Tracking details. From the website portal. You can go online.
Okay, it can make it the exams also. This court has no idea about what should be.
No, you usually do it, my lord. If they have to post it themselves, they just get the seal and signature from upstairs, the registry, and then they post it themselves. So it's through Dusty. So that is how.
That is okay. No, that is all right. We are talking about the report which has been.
The report we should await. We should await.
Item number 2.
May I please your lordship?
Yes.
Lordship, I have taken steps.
Yes.
Lordship, this is before I start my hearing, Lordship, I'll just like to just brief facts. I am plaintiff number 1 in 6 in a trial in a suit, and there are other plaintiffs also.
How many plaintiffs are there in total?
6, total 6. So why it is relevant that I am not all the plaintiffs, but I am 2 of the plaintiffs. I file a suit for issue regarding some landed property.
Not you. Oh, you all.
All of us.
There is one suit.
One suit.
So
all
you
of
have
us.
common interest involved.
All of us, yes.
You have relief.
The relief claim also is for.
Yeah.
And suit is 2 katha, some leches. 2 katha.
Suit land.
Suit land is 2 katha, some leches. And this relief I was claiming against the defendant.
Relief means what is your prayer in the thing?
Right, title, interest, lordship.
You say it's a declaratory suit.
Lordship, declaratory suit. No, defendants, they file a written statement. And during the pendency of the case, lordship, what happened?
How many defendants were there?
Defendants are four defendants. And during the pendency of the case, lordship, what happened? There was a talk of settlement, and this is where I have to just make this fact clear, lordship. So, some of the plaintiffs, that means me and one of the other plaintiffs, we had settled a portion of the suit land. Only portion of the suit land, not the entire land. Now, this settlement, lordship, this settlement of the suit land was done on the basis of a compromise deed. If I've just come to lordship to straight to the point at page 80, para 9. Lordship has got it. Page 80, the relevant part. This is part of the petition, Lordship.
Yes.
That it may be mentioned that one of the petitioners, Shri Nirmal Thapa, along with the other. 80, Lordship, sorry.
Paragraph 6.
Para 9.
Oh, para 9, yes. Yes, please.
That it may be mentioned here that one of the petitioners, Shri Nirmal Thapa, along with his other family members, had entered into a deed of agreement with Srimati Neeta Nevar. Lordship will kindly, just small request, Lordship will kindly, I'm emphasizing on the word deed of agreement. So it's not an oral agreement, it's a deed of agreement with Srimati Neeta Nevar, wife of so-and-so, void agreement dated 28/11/2019. In the said agreement, the petitioner so-and-so along with his 2 more family members agreed to withdraw themselves from any pending cases between them and Srimati Neeta Nevar, wife of so-and-so, regarding the above mentioned land, which was previously standing in the name of Shri so-and-so. In the agreement with so-and-so, in the deed of agreement, she has agreed to relinquish her claim over residential house consists of 3 rooms of the petitioner. Lordship, this is very important. So, as per the agreement, it's a deed of agreement, and then what is sought to be relinquished is her claim over residential house consisting of 3 rooms of the petitioner, so-and-so, which would be around the areas mentioned, Lordship, in the above mentioned periodic patta in favor of your petitioner, Sri so-and-so. Lordship, I will not bother Lordship with the finer details. The thrust of the legal argument is this: as per this deed of agreement, plaintiff has entered into an agreement with the defendant and a portion of the suit land, which is clearly stated, Lordship, residential area and the areas mentioned. And I am emphasizing, Lordship, the entire suit was not settled. Why this is relevant, Lordship? Because of the peculiar nature of this case. Other plaintiffs did not enter into the agreement. Only me and the other plaintiff. So whether this is permissible in law, that is very important, Lordship. And what is the provision that is the guiding light for such settlement? Lordship, I will have to admit, after the settlement, I filed an application. Lordship will come at page 79.
Yes.
This is an application, Your Lordship, that I filed.
Yes.
And Lordship, this application was filed under Order 23, Rule 1. Lordship, I have to admit very candidly, Your Lordship, that it was under the misguided understanding of law. It should not have been Rule 1, it should have been Order 23, Rule 3. Why, Your Lordship? I'll just come to the provision of law. But the section under which such application can be filed remains Order 23. The source of power is there. The only issue before the trial court was whether it should have been 1 or 3. Under 1, Your Lordship, I'm making a submission in the bar, Your Lordship, this petition will not be maintainable. But then the trial court, Your Lordship, trial court ought to have looked at the provision of 3, not 1.
Why?
Lordship, yes.
Why that responsibility is with the trial court?
I won't say responsibility with the court, Your Lordship. Maybe the lawyers did not understand this, the plaintiff lawyer or defendant. But be as it may, Your Lordship, for the simple reason, Your Lordship, if there is a deed of compromise, certain requirement has to be done. No, but
deed of compromise is a separate thing, isn't it?
Yes, it flows from
withdrawal of suit under Order 23 Rule 1 is another thing.
Absolutely correct. Absolutely correct.
Now, say supposing if you file an application by invoking Rule 1, how can there be an assumption that is an application under Rule 3?
Lordship, under Rule 23, Rule 1, the consent of all the plaintiffs is mandatory. That I am coming to that, Lordship. So I'm going a bit slow,
This is an
Lordship.
application filed by you, isn't it?
Yes. And
So you yourself challenge your action.
My challenging of the action is this, Lordship. My challenge of the action is this. That's why I admit, if Order 23, the parent order, the source of power flows from it, application of Rule or 3 is not something like we have resorted to different provision of law altogether. The factual situation before the trial court was 3, not 1. In that situation, Lordship, law is settled. Once the power, if there is a power, just by a wrong application, when the factual situation is different, will not say that I invoked a wrong section.
See, when can we have this benefit of that proposition of law?
Lordship, allow me. Yes.
When there are two different provisions speaks about two different things. Now you had the option of invoking Rule 1, you have the option of Rule 3, invoking Rule 3.
No, I didn't have the option, Lordship, I didn't have the objection for Rule 1 because under 1, Lordship, the consent of all plaintiffs are required and there is no requirement for deed of compromise.
Anyway, then what happened? After you filed this application, then what happened?
It was rejected. It was rejected only on a very simple ground that I did not comply with Order 23.
Then what happens if it is rejected? Does it forbear you from giving effect to your compromise?
Yes, Lordship.
If it is simple application for sample withdrawal and it has not been acted upon, you file an application, say that you have compromised and tell the court to partially decree the suit.
Lordship, that was rejected. I'll come to the impugned order, Lordship.
No. Where is the petition you have filed showing that you have compromised?
Lordship, page 79. This is the petition.
That is the application for withdrawal, Order 23, Rule 1.
My petition is included, Lordship, in this petition itself.
Even if it is rejected, why you will not have the bar to file a fresh application by invoking proper provision of law.
Lordship is correct.
So,
Lordship,
why you are here? Here, this is a revisional jurisdiction, isn't it?
Lordship, my limited prayer would be if the impugned order is set aside and a direction may be given for me to approach again. Because I'm barred by
there is
this.
nothing. If you set aside the impugned order, that means your prayer for Order 23 Rule 1 stands revived. So
not that, Lordship. Set aside and only limited prayer allow me to direct me to approach.
There is no. Why should we set aside? We will not set aside. We will just say that you have these things, because compromise of suit and acceptance of compromise is a different thing.
But Lordship will kindly appreciate one thing, that this again I'm taking a Lordship to a different law altogether. Principle of res judicata will be applicable, Lordship, if it's not set aside.
Why?
Res judicata is applicable.
What is the order of rejection?
Lordship will just come to page 88. Relevant part, Your Lordship, I'll just come to the relevant part, Your Lordship. Page 91. which is at
Yes, page 91.
Lordship, the second last paragraph, in that context.
Yes.
In that context, it is transpired that the plaintiff number 1 and plaintiff number 6, petitioners in petition number 6799.
There are two different petitions. Two different petitions.
Two different petitions. Jointly filed an
Who is the petitioner here before this court now?
Plaintiff number 1 and 6, Lordship.
They filed separate application, then why this common revision then? We do not know why these things are made in very, very complicated, unnecessary complicated.
Lordship, trial courts, this Lordship will clearly aware.
No, but then it is because of your action. If you have compromised, then where there was the need of filing two separate applications and both the applications under Order 23, Rule 1?
Lordship, that will not be relevant for the present purpose, Lordship. Just allow me to just read, please.
Please.
Jointly filed instance suit with the plaintiff 2, 3, 4 and 5. They are very important, Lordship, 2, 3, 4 and 5 for declaration right and interest of the entire suit land in question and not just for portion of the suit property in favor of the said plaintiff petitioner. In view thereof, where the right to sue is vested jointly in all the plaintiffs. This court is barred from permitting withdrawal, abandonment of plaintiff number 1 and plaintiff number 6, petitioner number 67 and 69 respectively, in absence of consent of co-plaintiffs 2, 3, 4, 5 at this stage of the trial, as permission of the same will be materially prejudice the co-plaintiffs. Lordship, consent of co-plaintiffs. The only finding of the trial court was consent of co-plaintiffs. Lordship, allow me to just take to Order 23.1. Lordship, I will not waste the time of the court so far reading the entire thing of Order 23 Rule 1. The thrust in Order 23 Rule 1 is this: it does not contemplate deed of compromise.
It's all right. It doesn't matter. See.
Lordship, just allow me this. Why that is irrelevant, Lordship? I'll just come straight to Order 23 Rule 1 Subclause 5.
Why don't we read the provision from the beginning?
Okay, Lordship. At any time after the institution of suit, the plaintiff may against all or any of the defendant abandon his suit or abandon part of his claim, provided that where the plaintiff is a minor or other person on whom the provision so and so in rules 1 to 14 of Order 2032 extended, neither the suit nor any part of the claim can be abandoned without the leave of the court. 2. An application for leave under the provision and sub-rules shall be accompanied by an affidavit of the next friend, and also if the minor of such other person is represented by the pleader, by a certificate of the pleader, to the effect that abandonment proposed is, in his opinion, for the benefit of minor or the other person. This is not applicable to us, Your Lordship. Where the court is satisfied that the suit must fail for reasons of some formal defect, or B, where there is a sufficient grounds for allowing the plaintiff to institute a fresh suit for the subject matter or a suit or part of claim, it may on such terms as it thinks fit grant the plaintiff permission to withdraw from such suit or such part of the claim with liberty or institute fresh suit in respect of subject matter of such suit or such part of the claim. Not applicable, Lordship, for our case. 4. Where the plaintiff abandons any suit or part of a claim under sub-rule 1 or withdraws from the suit or part of the claim without the permission referred to suit through, he shall be liable for such cost as the court may award, and shall be precluded from instituting any fresh suit in respect of subject matters or such part or claim. Lordship, I read out Order 23 Rule 1. 1, 2, 3, 4 are not applicable. Thus I was coming straight to 5. The relevant part is only 5. And how, Lordship? If you read again at any time, if I read again Order 23 Rule 1, Subclause 1, at any time after the institution of suit, the plaintiff may against all or any of the defendants abandon his suit or abandon part of his claim. Now if you continue with 5, Nothing in this rule shall deem to authorize the court to permit one or several plaintiffs to abandon a suit or part of a claim under subrule so, or to withdraw under subrule through any suit or part of the claim without the consent of other plaintiffs.
Yes, that is what has been invoked by the Learned Trial Court.
Absolutely, Lordship. Lordship will kindly appreciate when we read Order 23, Rule 1 and Subclause 5, nowhere it contemplates, it talks about withdrawal of part of the claim. It does not talk about deed of settlement or a compromise deed.
It's all right. We are not concerned with this. See,
Lordship,
what power you sought to invoke that matters.
Lordship, kindly allow me now to read Order 23, Rule 3.
I do not know why you have. What is the purpose of yourself approaching this court?
Lordship, Lordship,
just a second. Even after the rejection of your petition, if you still maintain that there exists some compromise between you and the defendants, you may have your remedy available.
Lordship, allow me to just read now Order 23, Rule 3.
It's not.
I don't have a remedy. I'll be barred by res judicata, Lordship.
Why?
Lordship will kindly see through 3. For a moment, just hear me out.
Question of res judicata.
Order 23, Rule 3, Your Lordship. Order 23, Rule 3.
Yes. Please. Yes.
Compromise of a suit. Order 23, Rule 3.
Yes.
Compromise of a suit. Where it is proved to the satisfaction of the court that a suit has been adjusted wholly or in part.
You are reading Order 23?
Rule 3.
Rule 3? Yes.
Lordship, I was reading first Order 23, Rule 1. Rule 1 has got 1, 2, 3, 4, 5. Now I am going to Order 23, Rule 3.
Yes.
Where it is proved to the satisfaction of the court that a suit has been adjusted wholly or in part. My case is part, Your Lordship, para 9. In part, by any lawful agreement. Para 9 talks about part and lawful agreement. This is not contemplated under Order 23, Rule 1.
Please go ahead.
Or compromise. In writing and signed by the parties or where the defendant satisfies the plaintiff in respect of the whole or any part of the subject matter of the suit, the court shall order such agreement, compromise or satisfaction to be recorded. Lordship, allow me to pause here for a minute. Court had to resort the moment an application came under Order 23, Rule 1, which I admit it was not the correct invocation of section, but court on appreciation of a compromise deed will have to first shall order such agreement, compromise or satisfaction to be recorded. The trial court overlooked, though the material was present.
3 was never invoked. What is the
Absolutely, Lordship.
Please complete the reading.
Lordship, I'm coming to that. And shall pass a decree in accordance therewith, so far as it relates to the parties to the suit, whether or not the subject matter of an agreement, compromise or satisfaction is the same as the subject matter of the suit. Provided that where it is alleged by one party and denied by the other that the adjustment or satisfaction has been arrived at, the court shall decide the question, but no adjournment shall be granted for the purpose of deciding this question unless the court, for reasons to be recorded, thinks fit to grant such adjournment.
Yes.
Lordship, two things, to my limited understanding, which flows from 3 is that if there is a written agreement, then you cannot apply Order 23, Rule 1. Order 23, Rule 1 and 5 talks about consent of plaintiff. It does not contemplate. Now, so far 23 is concerned, Your Lordship, the moment a written agreement comes,
So you want to say that if no suit can be withdrawn on the basis of a compromise,
Lordship, no.
It has to be end up by a compromise deed in terms of 23 Rule 3.
Lordship,
that is what your submission is.
Lordship,
you say when there is an agreement,
Lordship, that's not my
cannot be
submission.
invoked.
I admitted that Order 23, Rule 1 will not be applicable. I made a fair, candid submission, Lordship. It was
that so far as your petition is concerned.
My petition is concerned and the impugn order. Lordship, impugn order is concerned.
Now the thing is that
Lordship will kindly see the impugn order.
If your prayer under Order 23 Rule 1 is rejected,
Lordship,
does it preclude you
Lordship,
from
yes.
compromising the suit?
Res judicata.
Suit is a subsequent stage.
Lordship, res judicata.
Wait, they show us some decision. This compromise can be done at any stage.
Lordship will kindly see the page 91, the last paragraph.
Whether you will have the right to compromise the suit on behalf of the other plaintiff or not, that is a different question. But then so far as your plea is concerned, you can have compromise. Even after rejection of your initial compromise, you may subsequently compromise. So where is the bar? Where is the question of application of principle of res judicata here?
Lordship will kindly appreciate. Para 9 of my petition talks about a compromise deed. No, that has not been decided. Lordship, I understand.
Your rejection is solely for the purpose of
Order 23, Rule 15.
Rule 5. That is what?
And says no consent of other.
When
No.
it is provided there, when there is a rejection under Order 23, Rule 5, the suit cannot be compromised subsequently.
Lordship, my pleading on Para 9 was on that compromise deed.
We are talking about the law. Just show us the law. We are not talking about your pleadings. Tell us the law, where it is. If you say the principle of res judicata will be applicable, just show us on what basis.
Lordship, I am in a tricky situation. I'm aware of it because I am admitted that 23
Question of law, Mr. Khan, you have invoked this revisional jurisdiction. Your basic duty is to show before the court
Lordship,
there is a
my
jurisdictional error.
Lordship,
Show us which way there is a jurisdictional error.
Lordship, my basic thrust would be here. The moment I have stated in Para 9 of my petition, there was a compromise deed. Trial court has misdirected itself by invoking Order 23, Rule 15.
Okay.
So, Lordship, trial court has assumed jurisdiction.
Where is that statement made?
Lordship will just come to, again, Lordship will come to page 80, Para 9.
Page 80? Yes.
Para 9.
Para 9. Okay.
I'm sorry, Lordship, because there's slightly.
The kind of question which you are raising, that requires some law to be done. Otherwise, this court will definitely not go and.
Lordship will kindly appreciate one thing. Even if I withdraw all my submissions.
Two things which this court has pointed out to you. First, show us that rejection of application under Order 23 Rule 1 will bar subsequent filing of application under Order 23 Rule 3. Any law?
Lordship, for a moment.
Let us assume that the trial court has overlooked that thing. And why? What was the need of the court? Basically, to convert this application from Order 23 Rule 1 to Order 23 Rule 3. Is there anything shown in the order that you have made that prayer before this court?
No, that's Lordship I submitted. Lordship, that's why I submitted. The power flows from Order 23. But then the issue was 1 and 3. Lordship will kindly appreciate the ingredients of 1 and 5 does not contemplate a deed of compromise. If it did not contemplate a deed of compromise, trial court, by rejecting in Para 91 that consent of other plaintiffs as required under Order 1, Rule 15 was not met out and rejected.
Anything else?
Lordship. Second argument is this. If it did not contemplate and trial court has rejected saying the consent of plaintiffs is required, that is exercising jurisdiction not vested in law. The consent of co-plaintiffs was not required. Because the entire Order 1, Rule 15, the court had misdirected itself.
Please repeat it again.
Sorry.
Please repeat your submission again.
The court had rejected in Para 91, Your Lordship, on the ground that the requirement of Order 23, Rule 1, Subclause 5 was not met because other co-plaintiffs' consent was not taken.
So you want to say that here the sum and substance of your argument is that since that application was filed based on a deed of compromise.
Absolutely, Lordship. I'm grateful.
The trial court would.
There was a material.
Considered this application
Material was there,
under
Lordship.
23
Material was there.
And there should not have been an occasion for the court to invoke Order 23 Rule 5. Yes.
Absolutely. By doing that, Your Lordship, it has misdirected itself and it has assumed jurisdiction.
Any decision of law in that thing?
Lordship, it's on the face of it. I don't think so.
Do you have a decision? No, you do not have.
On this issue, no, Lordship. I'll make a lead. Your Lordship, I am relying on a pleading of para 9. If there was no material, Lordship was very correct. Then, Lordship, what has fallen from your Lordship, I'm very grateful, Your Lordship. That situation would have arisen. I can again file a new compromise. I can find a new compromise. Lordship will kindly appreciate my dilemma. That can occasion never arise, because then the plea of the respondent, defendant will be, your compromise deed was then para 9. How can you have a new compromise?
Yes.
Now, if this material was present and trial court has misdirected itself by invoking Order 23, Rule 15, it has assumed jurisdiction not vested in law. Because
it means you want to say
Order 23, Rule 15 does not contemplate a deed of
just let the court understand the way it understands. You want to say that the rejection of application would means the rejection of the compromise deed also.
Absolutely.
So there
correct.
cannot be a fresh.
Because there is a pleading. I am very grateful, Your Lordship. Had that compromise deed not been there in para 9, Your Lordship, then I would have not come. Lordship, I would have again gone back. I can't go back, Lordship. Because it is an admitted fact. And it was a matter of record.
Yes.
My second argument, Lordship, is this: the trial court has misdirected itself.
You have already made 3 arguments. Now it cannot, no use of coming back to second. It will be 4th argument. Yes.
Lordship, I am also aware that this is
Your first argument is Order 23, Rule 1 does not contemplate.
Correct.
Any deed.
Correct.
The second is that since this petition was based on a compromise petition, the trial court could not have treated this application under Order 23, Rule 1. It should have invoked Order 23, Rule 3.
Rule 4.
Order 23, Rule 3.
Rule 3. It rejected on 5, that is, on the face of it, exercising jurisdiction not vested in law.
Since this petition based on this thing, on that count, Order 23, Rule 5 also could not have been.
Absolutely correct, Lordship.
Yes. Yes, and then your last argument was that rejection of your petition means the rejection of the deed of compromise.
Because it was part of it, para 9.
So it cannot be revived.
Para 9, because para 9, Your Lordship. Because,
Okay.
and it's a rejection, Your Lordship.
Yes. Anything else you want to say?
Last, Your Lordship, last legal argument would be, the issue is Order 23. It is not that I have invoked Order 25 or 26, wrong provision. It is within the power. The latitude is given within Order 23, 1, 2, 3, 4, 5, or 1, 2, or 3. The source flows from Order 23.
So you want to say that basically this is a duty cast on the thing that, or cast on the court to see where this application would suit. It is not that what provision you invoke. It is the duty of the court to see where this petition will fit.
Lordship, can I just absolutely?
See, Mr. Khan, are you aware of what argument you are raising?
No, Lordship.
We do not know where, like in which dimension or which way you interpret law. But then that is what the meaning of your argument.
Lordship, for a moment, I am not saying it was a duty of the court.
Now, if you say that,
I am not saying it was a duty of the court, Lordship. I am saying now, can I raise this argument before this honourable court to correct a mistake which is legally not sustainable, though it may not have been argued.
Mistake means what mistake? What do you refer to?
When I say mistake, Lordship, because I am not arguing before a trial court. I am not saying trial court is wrong. For a moment, I am not saying. What I am saying is
No, you have to say trial court is wrong. Otherwise, we cannot interfere in the revision application.
Lordship, I am saying
There has to be judicial error.
First of all, Your Lordship, Order 1, Order 23, Rule 5 is on the face of it illegal order. It is exercised jurisdiction not vested in law or virtue of.
You have said it.
Yes.
You have already said
Yes.
it.
Now, Your Lordship, Lordship, what I am saying is this: before the Honourable High Court, can I raise this plea of illegality of law? It ought to have exercised 3. There are 2 situations. I want to conclude my argument. There are 2 situations.
You see,
either court set aside and says
you have made your submission, but then you have not shown us any law that court should have treated this application under Order 23 rules. There is no law. You have not given us.
Lordship,
Just because if your contention is that since this application was supported by an agreement, the court should have treated it application under Order 23 Rule 3. By overlooping the very provision which you have quoted in the petition.
Lordship, can I simplify my argument? Supposing for this moment, if I, Lordship, I agree with the Lordship, I says, okay, I don't forward even the argument of Order 23, Rule 3. Let me just confine, but I'm not conceding, let me just confine to Order 23, Rule 1 and 5. Set aside that order. Just set aside and leave it to the discussion with the party. Let's forget about everything else, what was argued and not argued. Because Order 23, Rule 1, Subclause 5 does not contemplate.
If we set aside this order,
Leave it to the discussion of the party to choose what they want to do.
Just a minute. Then what would happen to your petition which you have filed before the trial court?
I'm grateful, Your Lordship. That is where I am building up my argument. The moment you set aside, Lordship, the moment you set aside, I'll be just guiding this court. The moment you set aside, court will rely on Para 9. By virtue of Para 9, liberty is given, the impunota is set aside, and parties are directed to approach the court and argue the matter afresh.
Yes. Order anything else?
This is my last argument, Lordship.
Yes.
Because there's nothing much on that.
All right. Yes. Who is appealing for us?
Your Lordship, I am appealing for respondent number 5 to 8.
You are plaintiff or defendant in the original suit?
I am the plaintiff, 2, 3, 4 and 5.
3, 4 and 5. 2, 3, 4
and 5.
You are just adjust your microphone. We are not really audible, Mr. Pasque.
Your Lordship, I am audible now.
Yes, you just say you are appealing for the respondent number.
I am appealing for respondent number 5, 6, 7 and 8. And in the
we are not again audible. You are not audible again. Adjust your.
Lordship, he is appearing for 5, 6, 7, and 8. Lordship.
And who is appearing for 1, 2, 3 and 4?
Lordship, I am appearing for 1 and 4.
Lordship, I'm for 2 and 3.
1 and 4.
Just let us go serially. Just a minute. You are for 1 and 2, Mr. Sheikh?
Yes, Lordship.
Yes, what is your submission?
My Lord, here I am supporting the case of the petitioner, Lordship. Here I am the defendant in the trial court.
Okay.
Here I have entered the...
Your defendant number?
1 and 4 in the...
Original, main suit.
Original title suit, Lordship.
Okay. You are supporting?
Yes, Lordship.
Yes.
Because so far as the claim against me, by virtue of the agreement, has abandoned the claim, Lordship. The trial court could have treated that application as application under Order 20.
Under what law? You say could have treated. You see, there is a difference between could have treated and should have treated. In the revisional jurisdiction can be invoked when you can show that should have.
Lordship,
just because could have will not give you a right to come and invoke the revisional
my
jurisdiction.
Lord will ever that mere wrong mentioning of...
We are kindly understand, we are in a revisional jurisdiction.
True, Lordship.
If there is improper exercise of jurisdiction, that we may. But then if there is a proper exercise of jurisdiction, but then according to you, the jurisdiction could have been exercised differently, that cannot be a ground for interfering in revisional jurisdiction.
Lordship, the trial court has exercised the jurisdiction incorrectly, Lordship. There was a wrong...
Which way? Why?
My Lord, the content of the order, Lordship, she has assumed she has passed the order in terms of Order 23, Rule 3, Lordship.
Not 3.
How come the rejection part is by invoking Order 23, Rule 1.5? Then?
My Lord, what I am saying, Lordship, the trial court should have accepted the application and the suit.
Trial court has accepted and rejected because of non-compliance of Order 20 Rule 1.5.
Since there was a agreement between me and the plaintiff, Lordship, the claim against me could have abandoned.
You are going to the facts and all that. Show us the about law. We are in a revisional jurisdiction.
That is my
You know, in revisional jurisdiction, interference can only be in case where there is jurisdictional error. Now tell us where is the jurisdictional error there.
Hello, I'm just
Do not go to the merits. Say as the jurisdictional error. Jurisdictional, if you say that. Otherwise, you are supporting.
I am supporting the case.
Yes. Yes, you are for?
1 and 4.
You are for?
Respondent 2 and 3, Your Lordship.
You are for?
JHDC
3 and 4.
2 and 3
Oh, Mr.
on behalf of the arguing counsel.
Mr. Sheikh is for?
1 and 4, Lordship. 2 and 3, they are the
Just a
defendant.
minute, 1 and 4.
Yes, Lordship.
And the defendant number?
Same, Lordship. 1 and 4 in the.
Okay.
There also I am 1
Then
and 4.
who is defendant number 2 and 3? District Council.
Yes, Lordship. They are also their defendant.
2 and 3, 2 and 3 here.
Yes.
So it is Mr. Paske who is the contesting respondent.
Yes.
What do you say here, madam?
I will not refute, Your Lordship.
Hmm?
I will not refute on behalf of the arguing counsel. I will not refute
What?
regarding to the arguing.
So you are also with the petitioner?
Yes, Your Lordship.
What is your name, please?
As Dhar, Your Lordship.
Yes, Dhar.
Yes.
Yes, now Mr. Paske, everything is on you.
Yes, Your Lordship.
You are the
May I
sole
please, Your
fighting
Lordship?
soldier in this case.
May
Yes.
I please, Your Lordship?
Yes.
Your Lordship, the present civil revision petition that has
Again,
been
you are not
filed by the-
audible. Again, you are not audible. There is a problem.
Your Lordship, am I audible now?
Yeah, a bit.
Your volume is very less. Please increase your volume.
Your Lordship, may give me
Yes,
kindly
yes. Now
few-
it's all right. Now it is
few
all right.
seconds, Your Lordship.
Yes, please.
Your Lordship, the present CRP, the civil revision
Probably
petition
you
that
must
has
be
been
near
filed by
near
the-
to your device. Just come near to your device. If you go behind, we cannot hear you properly.
Your Lordship, the present civil revision petition that has been filed by the petitioner is challenging the order of the trial court dismissing the application under Order 23 Rule 1 for withdrawal of the claim from the suit. Your Lordship, am I audible, Your Lordship?
Yes, you are audible, but then your volume is very less. I have a problem in hearing. That is why I speak loudly also.
Your Lordship, I am not that tech friendly, Your Lordship, so I completely apologize for the error on my part.
No, sometimes you are audible. Now you are audible in very nice way. But then again sound drops somewhere. Sometimes and then yes.
Your Lordship, my submission in respect of the CRP
This
is
is the
that
problem. See, he goes up and he suddenly comes down.
He comes near the mic. Your Lordship is correct. He just comes near
That
the
is
mic.
what the problem is.
He comes
And you
near-
cannot, you see, control the motion of a man when he speaks.
So my humble submission, Your
Yes.
Lordship,
Yes.
is that the trial court has correctly applied the principles laid by the Honorable Supreme Court. And since the application that was filed was under Order 23 Rule 1, so there is a clear bar on withdrawal without consent of the co-plaintiffs, Your Lordship. Your Lordship, I would like to take you to the impugned order at page 90.
Just a minute, please. Yes.
Your Lordship, page 90 of the impugned order.
Yes. Page 19.
90, Your Lordship, of the impugned order.
Yes.
Your Lordship, the second para, which reads as the arguments by counsel for the plaintiffs 2, 3, 4, and 5.
Just come near your
Lordship,
microphone. Argument for?
Arguments by counsel for the plaintiffs 2, 3, 4, and 5. Your Lordship, page 90.
Yes, yes.
Your Lordship, this is, may I read this argument, Your Lordship?
Yes, please.
Learned counsel submitted that the other plaintiffs he is representing are not privy to the documents filed by plaintiff 1 and plaintiff 6, and the deed of agreement is between the defendants and plaintiff 1 only, and not the other co-plaintiffs, and raised objection under Rule 5 of Order 23. That the petitions for withdrawal has been filed without the consent of other plaintiffs, as the plaint has been filed jointly by all the plaintiffs.
Yes. That is
Your
what you have said here also, the same contention.
Yes, Your Lordship. Your Lordship, I want to take you to judgment of the Honorable Supreme Court, reported in 2018, 12 SCC 584. The list of books has been given, Your Lordship. Your Lordship, 2018, 12 SCC 584.
Yes.
Your Lordship, para 20. I'll take you to the relevant para directly, Your Lordship.
Yes.
May I read, Your Lordship?
Yes, please.
Sub-rule 5 of Rule 1 says that if there are more than one plaintiff, then unless all the plaintiffs give consent to withdraw the suit, the permission to withdraw the suit cannot be granted under Sub-rule 1 or 3.
Sub-rule 3.
Yes, Your Lordship. And Your Lordship, again, para 22, Your Lordship, it is pertaining to this judgment wherein there was only one plaintiff, so the compromise was allowed. So here it stated, I'll read it, para 22, third line, Your Lordship. Since only one person had filed the suit, and therefore sub-rule 5 of Rule 1 was not attracted.
It's okay. These are settled position, Mr. Pasque. We do not have to go through this. We can understand the provision of this thing. That is very clear from reading of the provision. Yes.
Your Lordship, why the rights of the co-plaintiffs shall be prejudiced as the claim is for the same land without any division. Hence, it cannot be permitted. That's
So the claim was with regard to one land. It was an undivided land. It was not partitioned.
Not partitioned, Your Lordship. Not divided. Hence, the law also says the same thing.
Yes.
Secondly, Your Lordship, just one last submission. Your Lordship, the compromise as placed by the petitioners herein was in the year 2019, whereas the suit was jointly filed in the year 2021, February 2021.
Is it? Okay. That's
the interesting part, Your Lordship.
Okay. Very interesting. So it means there was no compromise after the suit was filed.
Absolutely, Your Lordship. Your Lordship may come to
yes. Okay, that is a very vital point. Where is the page?
Your Lordship, I take you to the page, Your Lordship. Your Lordship, the suit has been annexed as Annexure 1. So that's at page.
Yes, that is at page
At
58.
page 18, Your Lordship.
Page 58
Page
it is
18.
there, isn't it? Page 58. Come to the page 58.
Yes, Your Lordship.
Okay.
This is 2019, 28/11,
Yes,
2019,
yes.
the
Very
date
correct.
of the agreement.
So the question of invoking order 23, 3 was not at all called for, isn't it? It's not at
Yes,
all.
Your Lordship. Absolutely, Your Lordship.
Basing on the materials on record, 23.3 could not have been invoked. Yes. Suit was filed on when? Which date?
21 Lordship.
Your Lordship, the date could not, but it's in month of February 2021, Your Lordship. Lordship, at page 31, if Your Lordship may come. Page 31, Your Lordship. Your Lordship, the verification part is February 2021 at Tura. Last part, Your
So it
Lordship.
was
That's
suit
the
was
affidavit.
filed in February 21.
Absolutely, Your
There
Lordship.
is no dispute to this.
No, Lordship. It's an admitted fact, Lordship.
Yes.
Agreement compromise was before the suit. Yes.
Okay. Anything else, Mr. Pasque?
That's all. My humble prayer to this honorable court is to dismiss the
Yes.
civil revision petition file.
Yes.
Uphold the trial court's order rejecting the withdrawal application.
Which we'll do this. Here we'll do it in chamber. Okay, we'll pass order. We'll pass order.
Lordship, just two clarifications.
Deeply obliged, Your Lordship.
Yes.
I just want to reply to it, Lordship.
Please. 1 second, please.
First, Your Lordship, the Supreme Court judgment, para 20 and 22. Lordship, if you read para 22, the facts of the matter was the entire suit was withdrawn.
Supreme Court judgment restricts only provision, nothing. It
No,
says
nothing. So
except what-
that's Lordship, except for the provision. First thing is this. Second thing, Your Lordship, it is an admitted fact, because we went into the legal part of it. It is an admitted fact that compromise was done in 2019. Why we approached the court, Your Lordship, the details are there absolutely in the entire petition. The entire details are there. Why? Because it could not be effected, we had to file a suit. Number two. Number three, Your Lordship. My third reply would be, Your Lordship, what happens to a compromise degree under Order 23, Rule 3? Lordship, just allow me to read 23 for a minute, just to.
You argued all those things. You just reply to his thing.
No, I'm replying.
You are
Lordship,
again reopening the argument.
No, I'm not reopening, Lordship. The moment a compromise deed, there is no bar for me to bring a compromise deed of 5 years ago. What is the requirement under 23, Rule 3, Lordship? For a moment, Lordship, please, kindly just allow me. The court shall order such agreement, compromise, or satisfaction to be recorded.
All right.
So that requirement of law, Your Lordship, that requirement of law, if compromise comes, it is for the court. The duty is cast on the court to satisfy whether this compromise was effected, whether there was a malefide.
Yes.
And such satisfaction can flow only under Order 23, Rule 3. So the issue of facts that he has raised, Your Lordship, I have to reply, Your Lordship, because that issue of fact will arise through the satisfaction of the court only when the court is satisfied under Order 23, Rule 3. The satisfaction will not necessarily be in the favor of plaintiff.
It's all right. You have said it.
It can discard it.
You have said it.
But that is not the issue right now here.
All right.
Deeply obliged, Your Lordship.
This book.
All right.